I had exactly $4,218.63 left in my checking account when my younger brother told a judge I had forged our mother's will, stolen $312,000 from her estate, and hidden the proof on a silver USB drive that I had never seen before. It happened 3 weeks after I got discharged from St. Vincent's in Portland with 6 inches of fresh stitches across my abdomen and a paper bracelet still tucked in my coat pocket because I kept forgetting it was there. I was tired, medicated, and grieving in that numb, delayed way grief shows up when your body is already fighting something else. My hand shook so badly that morning I spilled coffee on the summons and had to hold it under the dryer. The hearing notice said I had 72 hours to respond to an emergency petition or risk immediate suspension as personal representative of my mother's estate. A restraining order was also being requested to keep me off family property I had paid taxes on for 11 years. My brother stood beside our mother's church friends outside the courthouse and acted wounded. He even lowered his voice when he lied. That was the first thing that scared me. The second was the USB. The third was how calm his lawyer looked. Let me take you back. My name is Mara Ellison. I was 46 then, a senior payroll manager for a hospital network in Portland, Oregon, and the sort of woman people trusted with passwords, house keys, and emergency contacts. My flaw, if I'm honest, was that I believed patience could fix character. I thought if I stayed calm long enough, selfish people would eventually feel ashamed of themselves. That belief cost me years. My mother, Helen, died in late October from a stroke that took her in less than 48 hours. She had been a school librarian in Gresham for 30 years. Careful woman, label maker woman, the kind who folded tissue paper after opening gifts because it could be reused. After my father passed, she made a small life around her church, her garden, and her 2 children, though around is not the same as equally. My younger brother, Nolan, had always been the golden child in the lazy family way some sons become golden without doing anything golden at all. He was charming, photogenic, quick with stories, and permanently one payment behind on some avoidable crisis. Our mother loved him with the anxious tenderness reserved for people who keep disappointing you in new outfits. She loved me too, but mine was the dependable kind of love. Functional love, the kind that arrives with paperwork. When Mom's health started slipping the year before, I handled the cardiology appointments, the insurance appeals, the leaking roof estimate, and the meal deliveries. Nolan posted old photos of her on social media with captions about cherishing every moment, and then forgot to pick up her prescriptions. He always had a reason. Traffic. Phone died. Client emergency. His client was usually somebody from his real estate office he was trying to impress over drinks. The first scar between us formed when I was 17 and he was 14. Mom had put aside money for my senior trip to Washington, D.C. I came home one afternoon and found the envelope gone. Nolan had taken it to cover a dirt bike repair after he wrecked it showing off in a gravel lot. Mom made him apologize, but she still told me, "You're older. You understand setbacks better." I stayed home while my classmates went to the Smithsonian. Nolan got a second chance before I got a first one. The second scar came years later, after Dad's funeral. Mom had sat at the kitchen table staring at casserole dishes she didn't want, and Nolan had leaned against the counter looking at the house like it was an expired listing. "You know," he said, almost gently, "this place is too much for one person. Once things settle, we should talk about what it's really worth." Our father had been dead 3 hours. He said it the same way people ask whether you want cream in your coffee. That was Nolan's cruelty. Never loud, never sloppy. He dehumanized you by converting your pain into an asset class. After Mom's stroke, the doctors asked who had legal authority. I handed them the durable power of attorney and advance directive from my folder. Nolan blinked like the existence of paperwork itself offended him. Mom had signed those documents 2 years earlier at the office of a small estate planning attorney named Ruth Carver. I drove her there. Ruth explained every page in front of both of us. Nolan left halfway through to take a work call, and later claimed he had never agreed with any of it. Mom survived long enough to speak only in fragments after the stroke. On the last evening, while rain tapped the hospital window and the monitors made that steady mechanical sound that drains the room of ordinary life, she squeezed my fingers and whispered, "Do not let him mortgage the house." Then she looked toward the door, where Nolan was standing with his jaw tight, and added, "The blue folder. Ruth knows." I didn't understand all of it then. I thought it was grief speaking in shorthand. I found out later it was instruction. 3 days after the funeral, I was in surgery myself. I had ignored abdominal pain for months because there was always something else to do. It turned out to be an obstructed bowel caused by adhesions from an old C-section. The surgeon told me afterward that another 12 hours and the situation would have become much worse. So while Nolan was telling distant relatives, he was stepping up for the family. I was learning how to stand upright without tearing stitches. When I got home from the hospital, there was already a certified envelope waiting in my mailbox. Emergency petition, contest of will, allegation of fraud, demand for immediate injunction. Attached to it was a photocopy of a silver USB drive in an evidence bag and a typed statement claiming my mother had intended to leave the house entirely to Nolan because Mara had already been compensated through prior transfers. There had been no prior transfers. There had been no silver USB. And the alleged revised will was dated 6 days before my mother's stroke, on a morning when I had been sitting with her through a 6-hour stress test, while Nolan was in Bend for a charity golf event he posted about online. I put the phone face down. Then I called Ruth Carver. Ruth was in her 60s, compact, precise, and impossible to hurry. She met me the same afternoon in her office downtown. Her receptionist brought ginger tea because I was pale and still moving like someone twice my age. Ruth read the petition once, then again. He's asking to remove you as personal representative, freeze estate accounts, and block probate until authenticity is determined, she said. Can he do that? He can ask. And the USB? She looked at the photo. That, she said, is interesting. Ruth opened a locked cabinet and removed a file stamped Ellison, Helen M. Inside were copies of the original will, the trust summary, the deed history, and something else. A 1-page amendment to an irrevocable trust executed 11 months earlier. She slid it toward me. It was what Mom had meant by the blue folder. Under the amendment, the house had not passed through the will at all. Years earlier, after Dad died, the house had been transferred into the Helen Ellison Residence Trust. The amendment contained a fraud carve-out and a canary clause. Ruth explained both in the calm tone of someone placing dishes on a shelf. A fraud carve-out means a beneficiary can lose interest if they're found to have used deception, coercion, forged documents, or false claims to influence distribution. I stared at her. And the canary clause? I asked. It's not common, but your mother insisted. If a later document appears that claims to alter the trust or related distributions, and that document is not logged through my office or a designated successor, the mere existence of that unauthorized document triggers mandatory review and temporary suspension of the challenging beneficiary's claim pending a forensic audit. I blinked at her. My mother did that. Ruth gave me a rare, small smile. Your mother was a librarian. She believed in cataloging threats. The room went very still around me. If this USB was planted, Ruth said, your brother may have just stepped into the exact clause designed for him. The second folder changed everything. We still had a deadline. Ruth pointed to the petition. If you miss this, you lose everything. So we moved. Ruth filed an immediate response requesting denial of emergency relief, preservation of digital evidence, and independent forensic review. She also referred me to a litigation attorney, Daniel Cho, who specialized in probate fraud and civil asset tracing. Daniel was younger than I expected, sharp without being flashy, and the first thing he said after reading the filings was, "This isn't revenge. This is justice." He asked a question no one else had asked. Who benefits from speed? Nolan did, obviously, but Daniel meant something more specific. He was pushing for an emergency hearing before original records could be fully compared, before metadata could be reviewed, before the church board, where Mom had served as volunteer treasurer, could be contacted about a donor pledge she had made from estate planning proceeds. That was the social twist none of us had seen coming. Mom had pledged that if the Gresham house sold after her death, 10% of the net would go to the literacy fund at her church. The pastor, 2 board members, and the donor coordinator all had copies of a letter referencing equal division of the remaining proceeds between my children after debts and the literacy pledge. Nolan had forgotten that in trying to seize the whole house, he was also contradicting a donor instrument witnessed by half the church finance committee. Daniel said, "People lie more easily to family than to boards." The next 48 hours turned into paper, calls, screenshots, and silence. Silence is underrated in legal work. It gives arrogant people room to keep talking. Daniel sent a preservation notice regarding the USB, Nolan's texts, his email communications, and any draft documents connected to the contested will. Ruth contacted the notary listed on the alleged revised will. The notary had retired to Arizona and swore in an affidavit that the stamp shown on the copy was from a set reported missing months earlier. That mattered. Then Daniel hired a forensic examiner to review the USB after the court ordered temporary neutral custody. Meanwhile, Nolan escalated. He called me twice and left one voicemail. His voice was soft, almost pitying. "Mara, I don't want this to get ugly. You've been through a lot. Surgery, stress, all of it. Nobody would blame you if your memory's off. Sign the resignation as personal representative, agree to a private settlement, and I'll ask my attorney to withdraw the restraining request. I'm trying to protect you from public embarrassment." That sentence told me everything. Not because it was cruel, because it was practiced. I saved the voicemail. Then I waited. 3 days before the hearing, another problem surfaced. The forensic examiner found that the files on the USB had been created weeks after my mother died. Not modified, created. Someone had tried to falsify internal dates, but hidden metadata still showed software version markers from a later operating system update. There were also fragments of an LLC filing on the same drive. Daniel called me into his office and rotated his monitor. "Nolan doesn't know how much trouble he's in," he said. The LLC filing belonged to Cascade Bridge Holdings, a shell company registered 6 months earlier. The managing member was not Nolan. It was his wife, Tessa. The business mailing address matched a UPS store near his real estate office. The listed purpose was property acquisition and consulting services. My stomach tightened. He built a shell. Probably to move the house quickly after forcing a sale, Daniel said. Maybe to strip equity before probate closed. I sat down carefully because my body still wasn't fully mine. He looked at me for a second, then added, "There's more." A title search showed Nolan had already started informal contact with a private lender about a bridge loan secured by anticipated inherited real property. He was leveraging an asset he did not own. That kind of confidence doesn't come from hope. It comes from a plan. The public set piece arrived sooner than expected. Mom's Memorial Foundation luncheon had been scheduled months earlier by her church literacy board. It wasn't grand, exactly, but in our town it mattered. Donors, teachers, retired principals, church leadership, and a county commissioner would be there. Nolan had insisted on speaking because he wanted to honor her legacy. Daniel originally told me to stay home and conserve strength. Instead, I put on my navy coat, covered my healing incision with a support wrap, and went. The luncheon was held in a renovated hall near downtown Gresham with white tablecloths and framed black and white photos of old schoolhouses on the wall. Nolan looked perfect for mourning. Dark suit, modest tie, that solemn expression he used when he wanted strangers to think death had happened to him. He walked to the microphone and started beautifully. That was the worst part. He talked about Mom teaching children to love words. He talked about sacrifice, home, family, memory. He had always known how to speak in polished surfaces. Then he pivoted. "In keeping with my mother's final wishes," he said, "I'm pleased to say the family home will remain under my stewardship, so its value can continue supporting causes she believed in." Daniel, seated beside me, wrote 4 words on the back of the program and slid it over. Let him finish. So I did. Nolan finished to gentle applause. Pastor Reeve thanked him. Then Daniel stood. He didn't raise his voice. "I'm counsel for Mara Ellison, court-appointed personal representative pending final probate determination. Because Mr. Ellison has publicly made statements about estate assets currently under dispute, I need to correct the record." The room changed temperature. Daniel held up a copy of the donor letter bearing my mother's signature and church acknowledgement. Helen Ellison pledged 10% of net proceeds from any sale of the Gresham property to this literacy fund, with the remaining interest divided equally between her children unless modified through trust procedures documented by counsel. Murmurs. Chairs shifting. Nolan kept his smile on for a second too long. Daniel continued. "There is no valid record through estate counsel of any later instrument assigning the house solely to Mr. Ellison. There is, however, active litigation concerning an apparently fabricated digital device and a related shell company connected to anticipated transfer of that property." Tessa went pale first. That was the dramatic irony. Nolan had walked into a donor room believing he controlled the story, not knowing the board held documents that contradicted him. He reached for the microphone. That's outrageous. Pastor Reeve, who had known my mother for 25 years and hated disorder in public, stepped forward and asked in a firm pastor voice, "Nolan, is there or is there not a dispute over the estate?" Nolan said, "This is a family misunderstanding." Daniel replied, "No, this is a pending fraud inquiry." The county commissioner did the smart thing and sat very still. Then the donor coordinator, an older woman named Louise who had once corrected my grammar in Sunday school and still could, rose from her chair and said, "Helen gave me a sealed note to release if there was conflict over the house." Every head in the room turned. Louise walked to the front carrying a cream envelope from her handbag. She had apparently kept it all this time because that was the sort of woman she was. The note inside was dated 9 months earlier. Mom's handwriting, brief and unmistakable. If Nolan attempts to pressure sale, title, or distribution outside counsel, stop everything and call Ruth Carver. The room went silent. Nolan didn't melt down. That would have been easier. He did something more revealing. He laughed once, sharply, and said, "You're all overreacting." People stopped seeing him as a grieving son right then. They started seeing him as a man inconvenienced by witnesses. The hearing was held 4 days later at the Multnomah County Courthouse. I wore a loose black dress because my incision still ached when I sat too long. Daniel carried 3 binders. Ruth carried 1 blue folder, and a look I had learned meant someone else was about to have a difficult morning. Nolan's lawyer argued first. He called the revised will credible, the USB newly discovered supporting evidence, and my actions aggressive exclusion of a rightful heir. He said my medical condition and grief had compromised my administration of the estate. He tried to make exhaustion sound like guilt. Then Daniel began laying out the order in which reality had failed Nolan. First, the alleged revised will conflicted with a trust structure that controlled the property separately. Second, the canary clause had been triggered by the appearance of unauthorized dispositive material outside counsel channels. Third, the notary evidence was defective and likely fraudulent. Fourth, forensic metadata from the USB showed file creation dates after Helen Ellison's death. Fifth, the same USB contained fragments tied to Cascade Bridge Holdings, an LLC connected to Nolan's household and apparently formed in anticipation of property transfer. Sixth, donor records and a sealed letter held by church officials contradicted Nolan's public claims. Then Daniel did the thing that finished it. He played Nolan's voicemail. Not the whole thing. Just the part where Nolan urged me to resign, referenced my surgery and memory, and promised to spare me public embarrassment if I settled quietly. Intent is rarely announced in full, but sometimes people get careless when they think shame will do their work for them. The courtroom went silent. The judge, a woman with silver hair and the kind of patience that makes liars overconfident, removed her glasses and asked Nolan's attorney, "Counsel, before I continue, are you maintaining authenticity of the digital evidence?" The attorney looked at Nolan. Nolan looked straight ahead. The judge ordered immediate denial of the emergency petition, confirmed me as personal representative, referred the contested documents for criminal investigation, and entered a temporary injunction preventing Nolan and any associated entity from encumbering, marketing, transferring, or representing control over estate assets. She also authorized a forensic audit of the estate challenge and issued a narrow protective order barring direct contact with me outside counsel. Nolan tried to interrupt. The judge stopped him with one sentence. "Mr. Ellison, you appear to have mistaken probate court for a pressure tactic." Later, the forensic audit expanded. That mattered more than the hearing itself. Emails from Nolan's wife linked Cascade Bridge Holdings to a private lender. Draft marketing language described the Gresham house as available after internal family resolution. A paralegal investigator also discovered Nolan had approached one of Mom's old neighbors months before her death asking whether she was still all there and whether she had updated anything recently. He'd been preparing the story before he needed it. The district attorney declined immediate criminal charges on the forged because the evidentiary route was messy, but the civil consequences were enough to break the scheme. Under the fraud carve-out in the trust, Nolan's beneficial interest was suspended, then extinguished after the probate court found by clear evidence that he had advanced fabricated materials in an effort to alter distribution. His challenge costs were assessed against him. The court also approved reimbursement of estate legal fees from funds otherwise claimable by him. Then the private lender, once informed of the injunction and shell company ties, canceled the pending line and reported the matter to its compliance department. That was final justice in the way real life usually delivers it. No explosions, no speeches, just signatures, orders, freezes, and doors closing one by one. The house sold the following spring through a clean court-approved process. Mom's literacy pledge was paid in full. Taxes were settled. Costs were covered. The remaining proceeds were distributed under the trust terms as modified by the fraud finding, which meant Nolan received nothing from the property. He and Tessa eventually left Oregon after a license complaint hit his real estate practice over unrelated disclosure issues that investigators found while following the asset trail. I did not celebrate. I slept for 14 hours. 1 year later, I was back at work, but not at the same hospital network. I had taken a quieter position with a nonprofit clinic system where nobody treated competence like a resource to be mined. I bought a small townhouse in Selwood with a deep porch and a lemon yellow front door I probably never would have chosen before all this. I started eating dinner at a table again instead of over the sink. My scarf faded from angry red to a thin silver line. Sometimes I touched it without thinking. Ruth retired. Daniel still sends a holiday card. Pastor Reeve named the church reading room after my mother, which would have embarrassed her and pleased her in equal measure. There's a framed plaque there now with her favorite lines stamped beneath it. Order is kindness made visible. As for Nolan, I hear things in the sideways way families hear things when they stop being families and become weather reports. He rents now. He consults, apparently. People say he still tells versions of the story where he was misunderstood. Maybe he believes them. That is no longer my work. My work is smaller and cleaner. I protect my peace. I keep copies of everything. I do not confuse love with access anymore. I do not reward urgency when urgency arrives wearing entitlement. The hardest lesson wasn't that my brother lied. It was that I had spent years shrinking my own certainty to keep him comfortable. Boundaries felt cruel to me once. Now they feel expensive and therefore precious. Sometimes justice is dramatic. Mostly it is administrative. A clause, a timestamp, a donor letter, a judge who has heard this kind of voice before, a woman finally refusing to doubt what she already knows. If you've ever had someone try to turn your calm into weakness, I want to know what boundaries saved you. And if this story stayed with you, subscribe. There are more of us than people like Nolan ever expect.